Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this question bank series, we'll look at 2 questions on reserved legal activities, which falls under legal services in FLK1. Let's dive in. Here's the first question we tackle today. A mortgage advisor has decided to expand her business by offering legal advice and helping clients draft wills in addition to her mortgage services. Although she does not hold any legal qualifications, she has several years of experience in the financial sector. She intends to charge fees that are in line with standard market rates for these services. Is she allowed to provide this type of legal service? A. No, giving legal advice on wills is a reserved activity and she is not authorized. B. Yes, because she intends to charge no more than standard market fees for her services. C. Yes, this is not a reserved activity and she does not need to be authorized. D. Yes, she can provide this service as it is not a reserved activity, and she may also represent clients in court and will disputes. E. No, she must be supervised by a qualified solicitor to give legal advice of this kind. You can pause the video and think about it. The best answer is C. Yes, this is not a reserved activity and she does not need to be authorized. Under the Legal Services Act 2007, certain legal activities are classified as reserved legal activities, which require authorization by the legal regulator, the Solicitors Regulation Authority. These include exercise of rights of audience, advocacy in court, conduct of litigation, reserved instrument activities, e.g., certain property transactions, probate activities, specific types of will execution and estate administration, notarial activities, administration of oaths. Giving legal advice on wills or assisting clients with drafting a will is not a reserved legal activity, and therefore does not require legal qualifications or authorization, provided the advisor does not carry out any reserved probate activities or misrepresent herself as a solicitor. However, it would be illegal for her to represent clients in court, option D is thus incorrect, or to carry out any reserved probate work without proper authorization. Also, charging fair fees in option B does not change whether authorization is required, the nature of the activity is the key factor. Let's look at another question very similar to the first question. A mortgage advisor is planning to expand her services by offering legal advice and assisting clients in drafting wills. She does not hold any legal qualifications or professional legal authorization but has many years of experience in the financial sector. To build client trust, she markets her new service as a professional will writing and legal advice package and describes herself in promotional materials as a legal advisor. She intends to charge market rate fees and does not plan to represent clients in court or carry out any probate work. Is she permitted to offer this service in the way described? A. Yes, because drafting wills and giving legal advice are not reserved legal activities. B. Yes, because she does not intend to charge above market fees or conduct reserved probate work. C. No, because referring to herself as a legal advisor could amount to holding herself out as legally qualified when she is not. D. No, because drafting wills is a reserved legal activity and requires authorization. E. No, because she must be supervised by a qualified solicitor to offer any legal advice. The correct answer is C. No, because referring to herself as a legal advisor could amount to holding herself out as legally qualified when she is not. While drafting wills and giving legal advice are not reserved legal activities, there is a separate legal and regulatory issue: misleading advertising or holding oneself out as a legally qualified advisor. Using terms like legal advisor or professional legal services could mislead consumers into thinking she is legally qualified or regulated, which may amount to unlawful holding out under Section 21 of the Solicitors Act 1974, especially if there is an implication that she is a solicitor or legally regulated professional when she is not. Even though her underlying services are permitted, her marketing language and branding strategy could bring her into regulatory breach or even criminal liability, depending on interpretation and consumer impact. Why other options are wrong? Option A is technically correct in terms of activity, but ignores the regulatory risk of misrepresentation. Option B also misses the key issue. Fee levels are irrelevant to whether an activity or representation is lawful. Option D is incorrect. Drafting wills is not reserved, unless she enters into probate work. Option E is incorrect. Supervision by a solicitor is not required unless she is conducting reserved legal activities. The exam tip today. Be familiar with the scope of reserved legal activities under the Legal Services Act 2007 and the rules on holding out. Not all legal services are regulated. For example, will writing and general legal advice are not reserved and may be carried out by non-lawyers. However, a person must not hold themselves out as a solicitor or authorized person if they are not legally qualified. The SQE often tests this distinction between what can legally be done and how it is presented to the public. Want to unlock the secrets to passing the SQE with confidence? I'm giving away my exclusive ebook, SQE Success Secrets, absolutely free. Inside, you'll discover proven tips, powerful study strategies, and real insights from my personal journey, including how I passed SQE 1 on my first attempt with a top-tier result. Click the link below this video to grab your free copy and start your path to SQE Success today. Let's turn your ambition into qualification. Subscribe now to SQE Success and start your great SQE journey with confidence.